some considerations that stand out to the court in this case, and there are several, is first off the second count, the count of involuntary manslaughter, first-degree felony, causing another's death as the result of the commission or attempting to commit a felony on the part of the offender. And in this case, the court takes note that the felony that was the predicate offense here was not a minor one, but it was kidnapping. It was a second-degree felony, as has been pled to at count 4. So it was not something less onerous, such as attempting to burglarize a home or a low-level drug offense felony. It was a major felony, kidnapping, that was ushered in by the object of killing Dan Ott. And while you, Ms. Stanifer, you weren't the trigger person in this instance, I recognize that. Apparently you were not, but you did participate in what appeared to be not just a spur-of-the-moment commission of involuntary manslaughter that was conceived moments ahead of time, but this was a studied effort. This appears to have been a deliberative style method that involved more than just one person, but involved another person or persons, one of whom is the likes of Chad South, which I'm not punishing you for the misdeeds of Chad South, but when you're with someone like Chad South, things happen. And this fact that this event was more of a scripted one than a crime of passion, let us say, or even of short onset, makes for a more culpable act, a greater level of responsibility. And the obstruction of justice, it did prolong the agony of these people, even though the first count is from December of 2014, still, to obstruct the investigation into a crime of this dimension is very serious. And you had, for count 9, that took place almost in December of 2015. That was another opportunity to come clean, and you didn't come clean. It took the dogged, persistent efforts of law enforcement to smoke this out and to get this out, and you never did really come clean. And hearkening back to May 6 of 2006 when Dan Ott was killed, one would have thought that that would be the end of this. I'm done with this life. I'm done with crime. But no, it wasn't. It wasn't but about a year before you picked up charges for reckless operation of a motor vehicle and theft for stealing books from a college. That, I think, was then dropped to a lesser offense that you pled to. But then you went on for another 8 years of more crimes of all kinds. I mean, starting chronologically from September of 2007 until May of last year. You possessed criminal tools and stole, theft offense, a domestic assault with a plea to a lesser included offense, followed by probation, which you violated, 4 public intoxications in the early part of 2009, followed then by possession of marijuana, a DUI, evading arrest, followed by a violation of probation and issuance of a warrant, which is still pending in Macon County, Tennessee. passing bad checks, theft again, followed by probation, and another violation. This is all after '06, after Dan Ott was killed. Another theft, possession of methamphetamines, driving under suspension, manufacturing meth and related counts, possessing controlled substances and driving under suspension, another petty theft, another driving under suspension or driving on a revoked license. Now, I recognize Mr. Bosco's argument that most, if not all, of these offenses were driven by drug addiction. But there's still a measure of culpability. And there are 2 outstanding warrants, both from Tennessee. And then stepping back to prior to May 6, '06, you had a record that antedated the killing of Dan Ott. You had offenses, several offenses before that, including a juvenile record. So there's an extensive criminal record here, which is hard to turn a blind eye to when it comes to sentencing.